Hello, I'm trial attorney Neil Redmond coming at you from the Long Island Expressway. I just drove through the Midtown Tunnel, and I want to talk to you about the continuing steps to filing and having a personal injury lawsuit. Because this particular video, I want to talk to you about the Bill of Particulars. Okay, that is a very important document that must be exchanged with the defendants, and it must be done so in a very thorough manner. The problem with the Bill of Particulars being done is that we have to wait for the other side, the defendants, to give us their demand for a Bill of Particulars before we can answer it. So the steps are: we file the lawsuit, which is also known as the summons and complaint. Then we get back the answer. But the defendants have 30 days to put in their answer. And they usually ask for another 30-day grace period, which we reluctantly give them because we're trying to stay on good terms and deal with them in a positive way. So now we're out 2 times 30 is 60 days, 2 months. And then we get the Bill of Particulars, and it takes us a good 2 weeks probably to put together the Bill of Particulars in the most, effective, efficient way. And what is the Bill of Particulars? The Bill of Particulars spells out all of the particulars of the lawsuit. That's why they call it that. It starts out by giving the other side a little bit of personal information about you, the plaintiff, such as the last 4 digits of your Social Security number, your birth year, your address, of course, information about where the accident or the malpractice occurred, such as the location, the date, the time, the place. We give a little bit of an overview of how the incident happened, and we put in the law that applies to this particular incident. After that, we give them the medical aspects of the case, and that's, in my mind, the most important part of the Bill of Particulars is the medical aspects of the case. In other words, how did the incident or accident affect you, and what was your treatment? So we like to be able to get that information very quickly and to put it in the Bill of Particulars very quickly, but sometimes there's a holdup in getting that information, and that causes another delay. But generally speaking, if you, the plaintiff, can ever give us assistance in getting that information, either through using my chart, helping us upload that information off of my chart, or possibly physically going to the medical provider and obtaining those records, that would be helpful as well. Because remember, without the records themselves, we can't give them all the necessary information in the Bill of Particulars. So when it comes to figuring out exactly what your injuries were and exactly what your treatment was, we always go to the records. We'll look at the ambulance report. If you took an ambulance, we'll look at the emergency room records. We'll look at any physical therapy records you received, any MRI films, if you got a CT scan, did you go to any chiropractic treatment? Whatever medical records that we have, we will get, and we'll put that information in the Bill of Particulars, including, of course, if you got a surgery or if you got any injections for any parts of your body. All of these factors or all of these issues go into the Bill of Particulars, and we exchange that information with the other side as soon as humanly possible. Remember, our goal as the plaintiff's attorneys is to move the case along as fast as possible, right? And in order to do that, we have to get this Bill of Particulars done and out the door. And we will also be calling you and asking you, did you get any treatment that possibly we don't even know about? So that's critical that we ask you that, and you tell us that information, and you do whatever you can to help us get the records. Now, if you went to a medical provider that we have recommended, chances are that we're going to be able to get those records extremely fast and extremely easily. That means that all we have to do is send them a HIPAA authorization with one of your powers of attorney, and they will send back those records. On the other hand, if you got treatment at a hospital or emergency room or a ambulance, those reports are much more difficult for us to get. We do our best to get them as quickly as possible, but sometimes there's a holdup, and that's a situation where we would even ask for your assistance to get it in a more expeditious way, again, so we can get that document out the door. The bill of particulars also includes pictures of injuries, pictures of where the incident happened, if that's applicable. We include copies of the medical records, because the last thing we want to know, or the last thing we want to hear, is that the defendant can't go forward with the deposition because they didn't receive some of your medical records. Again, we will include copies of the HIPAA authorizations for the defendants to get the medical records, but the bottom line is that if we can speed up the process by providing those medical records, then we should do that. If there are any videotapes that would support your incident or your accident, we will include those in the bill of particulars. Now, the next step is that when we serve the bill of particulars on the defendant, we also file a document called an RJI and a request for a PC. RJI stands for Request for Judicial Intervention, and a PC is a preliminary conference. So our goal, again, is to move the case along. Remember, we get paid by doing a good job for you, of course, as quickly as possible. But remember, the other side, the defendants, they get paid by stretching the whole process out and taking their sweet time. So we have a little bit of a conflict there. The point is that if they take too long doing things, then we go to the court. We will make a motion, we will talk to the judge and find out what the heck is going on and push them along and ask for sanctions if they fail to do it in a reasonably quick way. After we file that request for judicial intervention with the court and schedule the preliminary conference, then we do the preliminary conference. Again, the holdup there is with the court. Sometimes they take their sweet time in setting up that preliminary conference. At the preliminary conference, we will meet with the other side. We will schedule the depositions, your deposition, the deposition of the other side. If there are any eyewitnesses, we'll schedule those depositions. And we will also set a schedule to exchange any other type of documents that we have or that we want from the other side. And so that's the process up through the completion of the bill of particulars and setting up the preliminary conference. Remember, I'm Neil Redmond. I'm a trial lawyer in New York City. And if you ever have any questions about the process, or if you're not happy with your current lawyer, you can always switch lawyers. You just call me at 844-NEIL-RED. That's 844-NEILRED. Thank you very much.